Partners Appeal on the matter of Phones for EE Ltd and EE Ltd and others. My lords, my lady, yesterday afternoon I had given you our short response to ground 4E, namely that the judge made a finding of fact that no substantive, or only a very short substantive conversation had taken place and no confidential information had been exchanged. And so I said, really, that is the beginning and end of ground 4E. But I was giving you a longer response and showing you the context. Yeah. And in very short summary, where I've got to is I've shown you the email of Mr Poissard, which talked about there being historic opportunity, given the Carphone Warehouse-Dixon's merger, historic opportunity in the market, and that the judge analysed that email and said that what that was all referring to was the possibility of a joint acquisition between EE and Vodafone of Phones for You. And the point I was seeking to make was that that was the context at the very time of the Sheen-Hull exchange, and Orange had been tasked by EE of going away and exploring that option. And it's in that context that Mr Nolo's email that my learned friend places weight on needs to be looked at, and that's in the core supplementary bundle tab 23 at page 1, in the red pagination at the top of the page, it's page 69.
Okay.
And it's the bottom of the page. So Mr McLean took you to this email, but you see the heading Indirect Distribution UK. And then you see again the announcement of the proposed merger between Carphone Warehouse and Dixon's is leading EE to rethink its distribution strategy, as there is a unique opportunity to break EE's extreme reliance on UK indirect distribution. So pausing here, the unique opportunity is the merger between Carphone Warehouse and Dixon's. That's creating a unique opportunity. And then over the page, you see EE thus has a window and a lever, depending on whether EE announces it supports the merger or not. And then what you see is a list of different scenarios. And these are scenarios that are all being considered. And we saw that in the judgment at the BRN meeting that took place.
Can I just pause there and clarify? My understanding is that the reference to support the merger relates to the fact that there were change of control clauses in the contracts with Carphone Warehouse.
I think I'm going to double check.
I had picked that up from somewhere, but it would be helpful if it could be clarified. In other words, that the merger crystallised the need to an opportunity to renegotiate.
Yes, can I come back, my lady, to that point?
Thank you.
Thank you. So now, looking at the different scenarios that are laid out here, these are all the scenarios that were being considered at the BRN, and we saw that in the meeting. And we see there that as far as and you see all the scenarios that are identified. Now, the only scenario that refers to Vodafone is the scenario of acquiring. Do you see that second bullet? EE is more inclined to analyse with the support of M&A shareholders, the shareholders being Orange and DT, of course, a scenario of acquiring Phones for You, possibly with Vodafone, and then sharing and rebranding the 400 Phones for You stores. And now, the bullet point that my learned friend relied on is the fourth one that refers to Ms Lambert's scepticism of acquiring Phones for You. So that's what was relied on by my learned friend. But you see here that this email simply doesn't bear the weight that he seeks to place on it, because it's of a piece with all of the contextual factors that are set out in the judgment. The historic opportunity being the merger between Carphone Warehouse and Dixon. This is shaking up the indirect market. You saw that EE referred to it as a game changer. Various scenarios are being canvassed. The only one here that involves Vodafone is a joint acquisition.
It may not matter, but it's just a matter of interest. What becomes more advantageous in value to Dixon's, which is much less dependent on operators than Carphone Warehouse, if EE does not support the merger project. So what's that got in mind there?
Yes, can I come back to that question?
I mean, it may not matter, it's not really relevant, but it's it's puzzling.
My Lord,
Because
yes.
Dixon's wasn't an operator, so I mean it wasn't an MNO, so
No.
it would have been equally dependent, wouldn't it, on?
I think what that must mean is that the merged, it becomes more advantageous to the merged entity of Dixon's and Carphone Warehouse. But if I can come back to that when I come back to my ladies.
I think that's probably not right. I think it means that the relative value of Dixon's would be greater.
Yeah, it could be.
Because Carphone Warehouse would be worth less. That's why I think this is to do with change of
Oh, I
control.
see.
Well,
Yes, I think that must be right,
and
Hayley,
that
yes.
would fit in, wouldn't it? Really fits in with your submission. What this is really all about is the possibility of either EE on its own or EE and Vodafone acquiring Phones for You in the same way as Dixon's has basically acquired Carphone Warehouse.
Yes. And that's as we saw.
It's
And
a
so
way
far
of
as-
dealing with the indirect.
Exactly.
market.
And so what you see throughout these documents is a reference, and the judge said, several EE witnesses said this, that the Carphone Warehouse Dixon's merger is a game changer because it's shaking up indirects. Undoubtedly, the MNOs wanted less dependence on the indirects, so they saw it as a game-changing opportunity. But what you can't
One
take
way of
out-
having less dependence is to take them over, isn't it?
Exactly. And what you can't take out of this email, in my respectful submission, is any suggestion here that one of the strategies being considered is a collusive exit with Vodafone from Phones for You. And that's really the short point. Now, and that would be an unfair reading of this document itself, which doesn't refer to any such collusive exit with Vodafone. But it also takes no account of the surrounding events that I showed you yesterday, which the judge obviously had very well in mind. And you will recall that my learned friend's submission was an extreme one, because he said in his submission that the judge had no evidence or submissions before him to support his conclusion that the topic that Mr Sheen wanted to discuss with Mr Hum was a joint acquisition. And that really is manifestly incorrect. You can see that from the passages of the judgment that I showed you, and from the documents which the judge had well in mind and which he analysed, the minutes of the BRM meeting, Mr Froissart's email, and indeed this email which he referred to. And aside from that evidence that he refers to in the judgment, of course, Mr Hum's own evidence was that this was the likely topic of the conversation that Mr Sheen wanted to have with him. And I don't think we need to turn it up, but it's in his witness statement at paragraph 65, which is supplement bundle 2, tab 20, page 455. Now, my learned friend's other point here, his other built-a point, is that the judge did not have in mind the scepticism of Mr Sheen or Orange itself, or others at Orange, about the idea of an acquisition. And that simply is incorrect on the facts. That submission has no basis in the facts. And if we could go back, please. Well, actually, let's start, please, with Mr Sheen's witness statement, because my learned friend took you to one paragraph of it. Sorry, just bear with me, because my file's down here. Thank you. So it's supplemental bundle 2, tab 19. And it's page 426. And you may recall in Mr McLean's submissions that he took you to paragraph 32, where Mr Sheen said, as a general matter, I would have been sceptical about an acquisition. In my experience, acquisitions can be expensive and always involve a degree of execution risk. Well, you see what he says there. But can I just ask you also to read paragraph 34, because that gives a little more nuance to Mr Sheen's evidence.
Yeah.
And then if we could go back, please, to the judgment. So, core bundle, tab 18, page 392. And you can see...
Quotes, doesn't he?
Exactly. So the judge has captured Mr Sheen's evidence very well. And so the idea that the judge didn't have in mind that Mr Sheen was sceptical of an acquisition, personally, is just simply factually wrong. And then further, the judgment is replete with references to the scepticism of others at Orange to a joint acquisition. Just by way of example, and there are more references in the judgment, but if we go back to the previous page, paragraph 463, you can see the paragraph, the reaction of the shareholders was as follows. On the Orange side, already on the 28th of March, Ms Lambert had expressed herself strongly opposed to the acquisition of TFEU. On the contrary, she favoured negotiating better terms with Carphone Warehouse. Then you see Mr Nolot recalled that he discussed this with Mr de Loison and Ms Lambert, and that he and Mr de Loison were also very sceptical about an acquisition, whereas it was the EE management that was pushing that idea. And then we see at 464 the reference to the Nolot email that Mr McLean says the judge did not refer to. Well, he's referred to it here. As I said yesterday, Mr McLean's submission is a much more narrow one, that he doesn't refer to it being forwarded to Mr Sheen. But the email is referred to here. And then if we go, please, at 466, you see a few lines down, Mr Dannenfeld recalled that DT was less strongly opposed to the idea of acquisition than Orange, but was also doubtful about it. Then at 467, you see at the bottom, Orange was very sceptical about an acquisition. And so the idea that the judge, just thinking back to Bilter, the idea that the judge omitted reference, the evidence of Orange being sceptical about an acquisition is really for the birds. But the fact was that despite Orange's scepticism, as I said yesterday, EE was keen on the idea, and Orange and DT, as the shareholders, were taking forward the proposal. And if you look at 475 on page 395, you can see in the middle of that paragraph, they did not dismiss this option out of hand, but pushed EE's management to present a thorough evaluation of the alternatives. And what we've seen in the contemporaneous documents, some of which the judge refers to in the judgment, is that Orange was tasked, as I said yesterday, with taking forward the proposal, and did do so. And in fact, if we move forward slightly in time to the 23rd of April, so some 20 days after the Sheen-Hum exchange, there was a shareholders' strategy meeting in Bonn. And if we go to page 398 of the judgment, please. And if we take it, in fact, from the previous page, 397, we see at the bottom of that page a reference to Mr Berger.
Yeah.
And his report, you can see there, if we go over the page, you can see his report talks about strategic aspects of the distribution market, Carphone Warehouse Dixon's consolidation discussions with Vodafone to be analysed by EE in conjunction with DT Orange Management Control, with support from M&A, Olivier Froissart as required. Now at trial, my learned friend's case was to say, discussions with Vodafone, that must mean collusion to leave phones for you. But what the judge found, Mr Berger was cross-examined about this document, as you see from paragraph 484, and the judge found that discussions with Vodafone was discussions about a joint acquisition, which is obviously the case, because in the same sentence, they're talking about support from M&A, Mr Froissart. So that's Mr Berger of Orange's note. So seen in this context, seen in the context of the other evidence in the case, which the judge thoroughly analysed, going back to the text between Mr Sheen and Mr Hum, which referred to a joint opportunity on the UK market, both the language of that message and all of these surrounding circumstances make it overwhelmingly likely that the judge was right to find that this was what Mr Sheen wanted to discuss. But you have my point from yesterday, which is that doesn't matter in any event, because the judge made very firm factual findings that they in fact did not discuss anything substantive beyond highlighting the fact that there was an opportunity on the UK market following the car phone warehouse Dixon's.
Well, if the judge, on the basis the judge dealt with the issue, then unless this court could say that no reasonable judge could have reached the conclusion that what was being discussed was joint acquisition as opposed to effectively wiping Phones for You out, then that's the end of it, isn't it?
That's the end of it, and the point goes further, my lord, because my learned friends put the point as a bill to point, so failure to look at evidence, and that's just blatantly wrong, because the key plank of their submission is evidence about orange scepticism, and that's just all over the judgment.
Yeah.
So, my lords, my lady, I'm going to come back later, because I need to take instructions on the question that my lady put to me about that sentence in Mr. Dollar's email, but subject to that, unless there are any questions from the court, those are my submissions on ground 4E.
Thank you.
My lord, my lady, just a few very brief points from me on the Vodafone side of this issue. We adopt Ms Dimitriou's submissions, and in particular the point she finished with. The bottom line is that the judge found that no exchange of confidential information took place, and that's a complete answer to the point. Beyond that, I don't repeat, but refer back to the... Sorry. Beyond that, I don't repeat, but refer back to the submissions I made in relation to ground 3 about this issue. The court will recall I submitted at the time of these exchanges, Mr Sheen and Mr Hum of Vodafone didn't have a strategy to disclose to one another, as the judge found in paragraph 576 of the judgment. Phones for You has offered no answer to that point, and I'm not even sure that the finding has ever been challenged. And if I can just show the court one additional reference in that context for colour, it's paragraph 347 of the judgment at core bundle, page 370. No, I'm sorry, maybe. Paragraph 347.
347.
I see, yes, it's 359, internal pagination. If I could just ask the court to read this, it's an email from Mr Hohenkamp of Vodafone back to Phones for You after a meeting on the 31st of March. It starts a little bit further up. The paragraph starts a little bit further up. Sorry, could you just scroll in the other direction? This is really a snapshot of the negotiations, completely contemporaneous with these exchanges, because there's been a meeting a couple of days before the text messages, and this email is sent a few days later. And you can see from the second paragraph at the top of 360 that on the Vodafone side, negotiations with Phones for You are very much alive. The negotiations have entered a challenging period after earlier meetings where Phones for You had revealed its financial constraints. But Mr Hohenkamp says, I agree it's important we continue the conversation to see if we can get to a point of agreement and so on. So that's the status of the negotiations, and that's why the judge found in 576 that Vodafone didn't have a strategy to leave Phones for You, to reduce reliance on Phones for You to disclose to Mr Sheen. So that's that point, and I also refer back to, but don't repeat, the submissions I made in relation to paragraphs 408 and 411 and 416 of the judgment, where the judge referred to the decision-making processes in Vodafone and EE, and made findings that, as far as Vodafone is concerned in particular, those internal deliberations were completely inconsistent with Vodafone having an insight into EE's plans. The judge found in strong terms that the internal documents showed the antithesis of EE's, of Phones for You's case. In paragraph 416, he found that it would be totally incredible if Mr Hum had confidential information about EE's plans from EE and then kept that to himself, allowing executives within Vodafone UK to continue to make plans in the dark. And that finding is not challenged. And in the course of ground 3, Mr Pickford made similar points about the EE side of the equation. He gave the example of paragraph 583 and 585 of the judgment, which show similar uncertainty on the EE side. So I asked the court to take those points into account when dealing with this issue. So those are my suggestions.
I'll just to answer my lady's question. So my lady was quite right. The answer is in Mr. Nolo's first witness statement, para 171, and his understanding was that EE could exercise change of control termination rights. So for Carphone Warehouse, EE's support was crucial. That explains, coming back to my lord's question about Dixon's, if EE didn't support the merger, then the acquisition would be cheaper for Dixon's.
Yeah. Yes.
My lords, my lady, I am going to address now 3 points on behalf of the EE. The main one is the ground 4 issue that Phones for You raises about alleged changes in EE's modelling. I'm then going to address the issue of the missing part of some minutes, and then finally the error in the presentation from offcom. And in addressing the first of those, the ground 4 point on the modelling, I'm going to return and draw together a point in that in relation to something that I foreshadowed on ground 3, because I said 2 points came together on that.
Yeah.
So on this ground then about the modelling, what Phones for You say is as follows. They say there was a dramatic change in EE's modelling assumptions on the 5th of May 2014. And they say that at that point, Mr. Eyre, who was in charge of modelling for EE, started basing his modelling on Phones for You collapsing and exiting the market. And they say that that dramatic change was based on instructions given to Mr. Eyre by Messrs. Alera and Milson at a meeting on the 28th of April. And they say that those instructions were predicated on collusively obtained information earlier in April, which Messrs. Alera and Milson knew, but Mr. Eyre did not, about Vodafone exiting Phones for You, which is why EE from that point on could be confident that Phones for You were going to collapse if EE also left. That's their theory. And their point under Bilter is that they say the judge ignored Mr. Eyre's own evidence about when and why he changed his assumptions. In particular, they point to his written and oral evidence about when what he inferred about his 5th of May modelling assumptions. Yeah. And so that's what they say the error is, and I'm going to seek to unpack that. Unfortunately, there's a lot that's wrong in that, so it's going to take me a little while to unpack it clearly. But in truth, it is simply an attempt to rerun points that Phones for You lost at first instance, not because of any defect in the judge's approach to evidence, but just because they are bad points. Now, what I'm going to do is to survey the evidence in summary terms, as best I can in the confines of the constraints of this hearing. And I say that 4 themes are going to come out from that survey. The first is that Mr. Eyre's evidence was not disregarded by the judge at all. On the contrary, he expressly noted Mr. Eyre's own doubts as to when his assumptions changed. And second, he legitimately focused, in part in the light of that, on the documentary record. And what that shows is that insofar as there was a key date to pick out from the evolution of EE's modelling, it was the 8th of May when EE's prediction about the impact of its exit on Phones for You did begin to firmly change, because there was modelling that underpinned its views at that point. That was the cash flow modelling, and we're going to come on to that. And that's entirely inconsistent with the Phones for You case, that EE's modelling changed rather as a result of the information that it got on the 28th, and therefore by the 5th, one had seen that all filter through. Second theme that's going to come out from the points I'm going to look at is, as regards the allegedly critical 28th of April meeting, the documentary record shows that the judge, and the judge found, and we say rightly, that Messrs. Alera and Milson and Eyre discuss scenarios where both Phones for You did and did not survive EE's exit. So it's quite wrong that as at the 28th of April, Mr. Eyre was being told that he could just from now on assume that Phones for You would no longer exist if EE left. The third theme that's going to come out from the evidence is that Phones for You has misrepresented Mr. Eyre's evidence. What the judge rightly found was that the 5th of May modelling marked a staging post in a continuous and gradual iterative process of modelling over time. And that's, we say, unsurprising for a party without a collusive plan. It's trying out different hypotheses. There was no sharp change in assumption, which is the impression that Phones for You has sought to give. And then the fourth theme, and perhaps the most fundamental, is this. EE's own assumption that it ultimately reached, that Phones for You would not be likely to survive EE's exit, was not predicated on Vodafone also exiting. On the contrary, EE assumed that if EE left, what would happen is that Vodafone would provide even more volumes to Phones for You, but that because Phones for You at that point would only be left with one major MNO, that they would have a short period of 8 to 9 months in which to find another, and if they couldn't find another, then they would go bust after that. And we say that is ultimately a complete answer to Phones for You's case on collusion between Vodafone and EE, whether that actually be under ground 4 or going back to ground 3, for reasons that I'm going to come on to explain. It's compelling evidence that there simply was no inside knowledge. So with that introduction, I've got 9 short points on the evidence, which I intend to draw attention, and by which I seek to explain that this ground's not going to go anywhere. So first one, Phones for You's case on modelling, as I've just explained, is predicated on Mr. Eyre only starting to contemplate Phones for You's exit after his discussions on the 28th of April in that allegedly critical meeting. And that is demonstrably wrong. If we could go, please, to the judgment at paragraph 447, and that's on page 388 of the bundle. We see here the judge quoting for some slides that were prepared for a meeting on the 20th of March. One gets that from just further up in the judgment. And we see O2's exit from Phones for You and proposed DSG's CPW merger has raised question marks about Phones for You's ability to survive in the market. EE is keen for Phones for You to remain in the UK market to maintain competition in the indirect channels and prevent a combined DSG CPW from dominating the sector. EE believes that Phones for You's survival is conditional on it maintaining at least 2 network partners, currently EE and Vodafone. So already there, it's because of the developments in the market, it sees that there are risks to Phones for You's survival, even now. And that obviously, the date of that is important because when one sees the 20th of March date in paragraph 446 of the judgment, it's important because that's before the 2nd of April, which is the date of the key alleged collusive contact between Vodafone and Orange. That's the first point. Okay. Second point is if we go to Mr. Eyre's email following that allegedly critical 28th of April meeting, the contemporaneous document that illustrates what he took from that is revealing. That's to be found in the supplementary bundle at page, it's volume 3, page 1069. So it's an email, it's from Roger Eyre, it's to Nicola Talbot, and it's about the actions from the meeting with Neil and Mark. So he's explaining about what went on. And he says, in the third paragraph down, beginning requests on the presentation you did on Friday, attached above, NTVS, we focused around scenario 2 as phones for you stop trading, and scenario 3 as phones for you continue. So it's clear that far from being instructed at that meeting that he can just focus on phones for you stop trading now because he knows what's going to happen. They're still thinking about both. They're still modelling both. So again, entirely inconsistent with what you've been told by my learned friend. Third point is that the next day, on the 29th of April, Mr Eyre has a further meeting with Mr Alera, and the judgment makes reference to those slides at paragraph 489. And so if we go to that, please, it should be at page 399 of the bundle. And if I could ask the court, please, to read paragraph 489. So what one sees there is that there's a worry on EE's part that if EE pulls out, Phones for You would sell the volumes to another MNO, and there would be negative implications. Again, inconsistent with the case that you've been told by my learned friend. Fourth point, we go to the 3rd of May, we see that Mr Alera Mr Eyre sent an email to Mr Alera, which is referred to in the judgment, and we'll go to the email first. It's in the bundle at supplementary volume 3, page 1074. And so we see towards the beginning of the email, second line, I keep coming back to a couple of questions, and it's probably worth you aligning with the board on, even if we don't have the numbers yet. And the second question is, how long do we believe Phones for You will survive if we pull out? And then down towards the bottom of the email, final two substantive paragraphs. First one concerns first pass at running Phones for You as a going concern. And then there's another one, if we pulled out Phones for You, lose £60 million. If we pulled out of Phones for You, lose £60 million, I beg your pardon. And so, again, she clearly showing there's no settled view yet on what's going to happen. They're again, they're wargaming, they're trying out different scenarios. And then if we go, please, back to the judgment and see how this is addressed there. We go to paragraph 520, which is on page 408. And we see, although Mr Eyre said in cross-examination that he thought that he'd reached the view that withdrawal by EE from Phones for You would eventually put Phones for You out of business following his discussions with Mr Alera on the 28th and 29th of April, that was speculation on his part, and certainly not a direct recollection. It's inconsistent with an email he sent Mr Alera on the 3rd of May, enclosing an updated version of the slide pack of the 29th of April, which had compared the benefit of acquisition as against exit, but retaining the slide which stated, if we exit, it is likely that they, Phones for You, survive, and we would force them into value-destructive actions within the market. We believe they would find another partner. Mr Eyre said that by destructive actions, he meant discounting on price. In his covering email, Mr Eyre observed that in the modelling scenarios, he kept coming back to a number of questions, as I showed you. And the points that I read out from the email before. So we say, in the light of the email in the accompanying slides, the judge was obviously entitled to find that this was inconsistent with some sea change in assumptions following the 28th of April.
Sorry, do we have the slides or are they not? We've got the email.
We have not got the
Okay,
slides.
thank you.
I think that's right. No, we haven't got the slides.
Right.
So, yes, what we see, as the judge says in the judgment at 520, is Mr. Eyre was clearly alert to the question of phones for use survival, but he didn't have a clear view as to its answer, as he would have done were the theory of the appellants correct, that he was basically told what he needed to assume on the 28th.
Yeah.
Fifth point, Phones for You has seriously downplayed, if I could put it that way, the equivocal nature of Mr. Eyre's supposedly neglected evidence about the assumptions underlying the 5th of May modelling. So if we go to that evidence, it's in the supplementary bundle volume 1 at page 107. Or rather, the relevant part of it that I want to take you to is. So we've been taken to this sub-paragraph, I believe, before. And he's saying here, given the draft modelling for scenario 1, i.e. signing an enlarged CPW contract and pulling out of Phones for You, as at the 5th of May 2014, was based on the absorption assumptions used in the sub-scenario 2 rather than sub-scenario 3. It's possible that this reflected a provisional view, of mine at least, that Phones for You were more likely to cease trading, follow withdrawal by EE than to continue trading. However, if that is the case, this would not have been a strongly held or particularly considered view at that stage. My overall recollection is that these absorption assumptions were a provisional but not unrealistic estimate at the time as to where we might end up if we were to pursue scenario 1. And then if one goes on to the next page, one sees a very similar statement. The external page is page 108, and I'm looking at Roman 4 in about the middle of the page, and we see a very similar statement about the inclusion in the draft modelling of the handset cost efficiencies and the very cautious inference that Mr. Eyre is seeking to draw there.
Yes.
And importantly, in addition to what he said in this evidence in chief, when he was being cross-examined, Mr. Eyre confirmed in relation to a question from counsel that all of his views on timings were merely inferences that he was drawing himself from the documents. I don't need to take you to it, but it's cross-examination, day 14, and page 40, line 8 to 12, and that's page 1432 of the supplementary bundle. So, in that context, the judge rightly did have regard to the contemporaneous documents, including the 8th of May slides themselves. And if we go back to see the analysis there in the judgment, we pick it up on paragraph 494, which is on page 401 of the judgment. I beg your pardon, the 5th of May, I misspoke.
5th of May.
5th of May, I beg your pardon. I'm getting ahead of myself. We come on to the 8th of May, but not quite yet. Yeah, so this is the 5th of May slide deck that the judge is referring to here. And he explains how on the next day he sent Mr. Alera a draft slide deck summarising the financial effect of 7 options. Position is not very clear, but from the cover slide, it may well be that this was prepared to be incorporated with the slides circulated the previous day, which Mr. Eyre had not prepared, to provide the financial modelling of different scenarios. Mr. Eyre's covering email stressed that the figures were a work in progress, which would be refined during the week. So we say what one can take from that is this was not the crucial round of modelling. It was, as I have said, it was a staging post, part of an iterative process. And then, if the court, please, could look at paragraph 495, there's an explanation there of why Mr. Eyre and Ms. Derbyshire had explained the significant change in absorption rates. And that was because of the new volumes that were under negotiation with Carphone Warehouse that they hoped to use to claw back contracts in the market.
Yeah.
And as the judge explains there, draft modelling certainly did not assume an early collapse of phones for you. Because what one sees in particular, it's in the quote, the proposal is that EE would only pull out phones for you in September 2015 at the end of its contract, and that's again inconsistent with the case that's being put by phones for you. Now, we say that this was an entirely adequate treatment of the 5th of May slides. There was no need for the judge specifically to mention in this context Mr. Eyre's equivocal statement about absorption rates and handset cost efficiencies that might have been predicated on a weakly held view that phones for you were more likely to cease trading. The core point, which we say phones for you is missing, is that just because some of the assumptions underlying the draft modelling are consistent with a phones for you exit, that doesn't mean that EE at that stage was suddenly firmly expecting that that was what was going to happen. You have to look at the wider picture and see this in context, just as the judge did. That's the 5th point. The 6th point is this. Mr. Eyre's attempt to infer his underlying assumptions and when they might have developed from the 5th of May slides formed part of a wider category of evidence which the judge squarely addresses. I've already showed you paragraph 520 of the judgment on page 408 of the bundle. That was the paragraph where the judge referred to the cross-examination where Mr. Eyre was suggesting that he might have reached his views following the discussions with Mr. Alera. But the judge goes on to explain why he doesn't think that Mr. Eyre got that quite right. And if one goes back one further paragraph, please, to 519, one sees more of similar analysis from the judge. And if I could ask you to read that as well, please.
Yeah.
So, the specific evidence that is referred to by my learned friends about the 5th of May work in progress, we say simply one instance of Mr. Eyre's attempted reconstruction of his thinking. And the judge dealt with such attempted reconstructions compendiously. Here, 519 to 520, he didn't need to refer to every single example. It was very clear he understood the basic point that there was some degree of discrepancy.
He was also making the point, which is perfectly understandable in the circumstances, that Mr Eyre was being asked to recollect timing and, if you like, motivation after what, the best part of 9 years.
Yes.
So the judge is saying, well, unsurprisingly, let's look at the documentary evidence and see to what extent that bears out what Mr Eyre is saying. And then he says, well, actually looking at the documentary evidence, I think Mr Eyre's probably got the timing a bit wrong.
Yes, quite. And
all of which is perfectly legitimate.
Exactly, I mean, because there's no suggestion that Mr Eyre was involved in any collusion here. So this would have been relatively uneventful from Mr Eyre's point of view.
It's just modelling away.
It's a day of work. I mean, if you ask me,
he does every day, isn't it?
Yeah.
And if you try to remember what you were doing on the 5th of May 2014,
I have no idea.
Without a document, you couldn't say, could you?
Quite. And all that Mr Eyre was doing, as he explained in his cross-examination, I certainly all that Mr Eyre was doing, as he said in cross-examination, it was his go at inferring from the documents, and the judge is saying, well, okay, I respect that. Obviously, you're a very truthful witness, but actually, I'm doing the same. I'm not ultimately doing the same exercise, and I'm the judge, and I think that you got that slightly wrong. So the 7th point concerns the 7th of May drill down workshop that occurs after the 5th of May, but it's what the 5th of May slides are ultimately working towards, and what that reveals. So on the 7th of May, Mr Eyre circulated slides in preparation for that workshop. If we pick it up in the judgment at paragraph 491, so it's back on page 400 of the book. So this is just introducing the workshop itself, and then the judge's analysis of the slides that were made for that workshop begins at 498. And if I could ask, please, the court to read paragraphs 498 and 499. So, is it appropriate for me?
Yep.
Thank you. So, beg your pardon. The judge notes that the absorption assumptions are similar to those in the 5th of May draft modelling, which was the draft slides that Mr Eyre was discussing in his witness statement at paragraph 58 that we went to. And he finds that those assumptions were made on the basis of Phones for You surviving EE's exit. And he supports that by noting a slide that shows that Phones for You would survive with a reduced market share. I can take to that slide, but I think it's probably unnecessary. I mean, one sees the analysis of it here in the judgment. If one looks at those slides, I'll give the court the reference, but I'm not going to. It's the reference to the slide is supplementary volume 3 1144. And what one sees from those slides is, firstly, phones for you are still assumed to be present. They've got material market share. And then at the back, there are various questions that are raised about, well, so what do we think? What do we think is going to happen to phones for you? And they're still debating those issues. Now, I showed you yesterday paragraph 585 of the judgment, where the judge recorded the 7th of May meeting, which was the meeting that these slides were prepared for, and we saw Mr. Milsom speculating about what Vodafone might do. And if you remember, it said that he thinks that it's going to be EE and O2 in car phone, because Voda's relations with CPW are deteriorating. And I explained yesterday that that's just totally inconsistent with the idea that, in fact, he'd had some collusively obtained information for the people he was giving those views to, because apparently what had happened on Phones for Use case is he'd been told that Vodafone were going to leave and go exclusively with Carphone, and therefore EE could approach matters on that basis, and he just gets that totally wrong if he's been given that information. He obviously wasn't given that information in the way that Phones for You allege. So where this leads, finally, on this point, is if we go to the judgment at paragraph 500, in an email that was sent after the 7th of May meeting, Mr. Eyre circulates an action point we see quoted in the first quote. What do we believe happens if Phones for You pull out, and how quickly does it happen? So again, simply irreconcilable with the case that my learned friend is asking you to accept. So that's the 7th of my points. I'll just have 2 more on the modelling. So the 8th is the cash flow modelling of the 8th of May, and this is an important issue. If we go, please, to the supplementary bundle, volume 3, page 1160. Get that myself as well. So we have here a covering email from Roger Eyre sent to Mark Alera, and it's for his cash flow modelling, where they're trying to predict, and this is where they're really beginning to grapple hard with the question, well, what do we think is actually going to happen to Phones for You? We've seen it in various conversations and slides at this to this point. They're wondering about that question, and then they try harder to answer it, and they adopt the cash flow modelling approach. And so they says in the end of the final paragraph, sorry, the end of the first paragraph, so 8 months to get a credible, large second player willing to pay cash up front. So many high-level assumptions, but this was about right, I think. They would collapse circa 8 months.
Is that 8 months after an EE exit?
It is, yes. So one can. I say one can. This is a slight interpretation because I'm now about to go to some Excel modelling. But if you look at the next page in the bundle. So if we could go please to page 1161. One sees the way that they've started modelling it, and the modelling starts in October 15. And the reason why it starts in October 15 is because the contract runs to September.
And then the next, EE cash shortfalls on the basis that EE pulled out, presumably.
Yes, exactly. And so what they work out from this is, well, one can see that things actually turn negative, I think, in January after about 3 months. But if you track through the closing balance and go through to July, one sees July 16 at the bottom. There's a closing balance of minus 40. That should be minus 54. And then if you go to the notes, you can see that there's a note. The second one up from the bottom says could probably do a fire sale of £50. I think it's £50 million. And my understanding is that the analysis was that although what it's assuming is that at some point they'd get £50 million extra cash, and that would keep them going basically until about July. And at that point, they're then out of cash.
And also, if you look at the block of figures at the top left, it's got 2011 cash, 2012 cash, 2013 cash, and that's then averaged over the 3 years. And then end of EE cash facilities, that's on the basis that EE comes out as at October 15,
Yes.
where they get the 46 from, the opening
Yes.
balance. So it's all predicated on EE having pulled out.
It's certainly all predicated on EE
But
having
it
pulled
also
out.
implies there's one left, which is Vodafone.
Yes, exactly.
Exactly. Yeah, exactly. Because
That's
of the
painful.
additional 10,000 volume.
That's paying from the assumption.
Yeah. And if one looks at the assumptions, the second assumption down, additional volume from Voda at only 300, with prepaid rev share could be up to double this at 6 million a month. So it's quite clear.
But that wouldn't help because it only goes up from 3 to 6. So all that would do is reduce the 54 million negative balance to 51.
Yeah, I mean, the key points the judge takes from this, and I'll come back to that in a moment, are firstly, when this kicks off, EE believes, is when EE leaves, when it plans to leave at the end of its contract. And obviously, if what EE knew was that Vodafone were about to leave in 2014, we wouldn't be modelling on this basis because things would suddenly get a lot hotter, a lot quicker. So
this is as at what date in May?
So it's the 8th of May 2014.
It's the 8th of May.
Yeah, and so what EE is doing is saying, okay, how long do we think Phones for You are going to survive? So they think the status quo until EE pull out. That's the move that happens.
But it must assume that Vodafone renews in whenever their contract terminates in 2014.
It's based on that assumption.
Yeah.
Yes, exactly.
It's based on the assumption Vodafone remain in fact, all the way through to the end, till September 16.
Yes, indeed. It's simply irreconcilable. It's I cannot reconcile it with the case of my learned friend, because what he says is, look at this modelling. This modelling shows you that there was collusion, and I'll show you why there was collusion. There was this big change on the 5th of May, and I've dealt with that. And what I say is, we agree with you. We totally agree with you that you can look at this modelling for a truthful insight into what EE was thinking. That's what their case is predicated on. That the modelling gives you a truthful insight into what EE was thinking. But when you look at it properly and you look at the whole of it, what it reveals about what EE was thinking is diametrically opposite to what Phones for You said. It shows that EE was proceeding on the assumption that Vodafone would stay in, and the reason why Phones for You ultimately go bust on these assumptions and on this modelling is because if they can't get another major player in the 9 months, and the implicit assumption in this modelling is that they won't be able to, they run out of cash. And the reason why none of this is particularly remarkable, it's worth remembering, of course, EE is the big player here. EE has, I think it was about twice as much volumes in phones for you as Vodafone did. So, if what began to dawn on them is that when they started doing the modelling, actually it really just it's all about what we do, and one sees this reflected in the judgment. So, if we go back, please, to 503 of the judgment. That's on page 404. I could ask the court, please, to read paragraph 503.
Yeah.
And then, additionally, just make sure I've got the right paragraph. Yes, 522, where the judge comes back to his analysis of the modelling. And he says there, Mr. Eyre also acknowledged that he recognised that if EE left phones for you, there was a possibility that Vodafone UK would do the same. But he said he had no such expectation. In support of its case that EE indeed had such an expectation, Phones for You sought to rely on a change in assumptions in its modelling. Therefore, a relevant question is whether EE's modelling was based on or reflected an assumption that Vodafone UK was likely to pull out of Phones for You around the same time as EE, leading to the likely collapse of Phones for You, well before the EE agreement expired in September 2015. In my judgment, it was clearly not so based. A. Mr. Eyre's calculation of Phones for You's cash flow had been conducted on the basis of Vodafone UK remaining with Phones for You, and indeed increasing the volumes which it took.
That's a reference to what we've just been looking at.
Yes, exactly. And then B, C, D, again, if I could ask the court to see those, but this is compelling reasoning by the judge, reflecting what I've shown the court, that Phones for You's case is simply wrong.
Yeah.
And then, very briefly, the ninth point, which is really just the coda to this, which is one sees from the judgment, if one goes back to 504 and following, the judge makes findings that the 12th of May analysis and then the 21st of May analysis, which were issues in the trial, reflect the development in EE's thinking on the 8th of May. So all the sorts of points that I've been making in relation to the 8th of May cash flow analysis carry over into the 12th of May and then the 21st of May. And indeed on 506, the judge notes that the slides now contain an express assumption that Phones for You would cease trading 9 months after EE's exit. So it's from then on, it's all of a piece, and he goes on to analyse further documents, but it's all now consistent with the core cash flow analysis that was done on the 8th of May. So, in conclusion, we say that there is no conceivable flaw in the judge's handling of the evidence of the 5th of May that would remotely justify remittal pursuant to the Bilter doctrine. On the contrary, if the judge's findings are sound, they are in fact a complete answer to Phones for You's case concerning collusion between Vodafone and EE, and that's for this reason. It provides, in particular, we say, a further answer on ground 3 as to why, even if there's a problem on its face in relation to ground 3, it can't ultimately go anywhere. Because Phones for You's case before this court is that it's, as I said, legitimate to infer what EEU from its modelling. And I've shown you what that modelling truly shows. And I say it should answer any doubts that this court might have about Phones for Use case of collusion at the time that they say collusion occurred, which was in and around April 2014. And remember, they need to make that case out because Vodafone, for a start, had taken its formal decision on the 17th of June to leave Phones for You. And what Phones for You say is that any information exchange would necessarily have been mutual. That's recorded at Judgment 576. Would it be helpful for the court to see that?
Yeah.
So Judgment 576, page 423. In the middle of the paragraph there's a quotation from Phones for You's re-amended particulars of claim.
This is the point about it being inherently unlikely that it wouldn't be a mutual exchange.
Exactly.
That's pleaded, although not between, as relates to these two respondents, is it?
Just a general plea, isn't it?
It's a pleading in relation to Intel and Vodafone and the pleadings.
Well,
But it's being relied on more generally here. I think it's a more specific pleading.
Yes, because if the principle is true, it's a generally expressed principle. And I say, well, if it's true there, it's true generally. There's no reason why we say it would be true in one instance and not in the other.
Yeah, I was just trying for accuracy to check.
Thank you. I'm grateful, Melody. So what Phones for You need to demonstrate is that there was collusion at some time that was prior to the core decisions being taken. Otherwise, they lose on causation. And so if we see what how the points that I have made in relation to ground 4 then play back into ground 3, let's assume that in ground 3 the judge was wrong to refer to the possibility that the information came from Carphone. He shouldn't have done that. There was a procedural flaw there. And let's even assume, I'm willing to assume against myself, that the information did come from Vodafone. I obviously have made it very clear before that I don't accept, even if there was an error at the first point, that implies that the information came from Vodafone, but let's assume in their favour that it does. What is clear, as I showed you yesterday on the face of the email, is that it was new information which undermined EE's expectation that it had in its modelling. And if we just look at that again, it's 1329 of the supplementary bundle.
Yes.
And whoever it came from, the fact that it was undermining and throwing off what EE's expectation had been is clear from the first two sentences of the final paragraph.
Let me just drop down. Yeah, he's asking really, isn't he? Mr. Milsom's asking for modelling to be done on the basis that Phones for You is going to collapse.
Yes.
Earlier than expected, i.e. in the next couple of months, which
Exactly.
it would do if Vodafone, well, if both pulled out, I suppose.
Yes, but critically, during the crucial period, this corroborates and confirms exactly what I've been showing the court, that EE's modelling was assuming that Phones for You was going to be okay, at least until 9 months after EE pulled out, which was going to be in 2015 and 2016. So in terms of the analysis that my learned friend requires for causation, even if the court has concerns about ground 3 on its face, ultimately it can't go anywhere because it comes slap bang up against the causation problem. So that's all I have to say on the modelling.
Right.
And that's by far the biggest of my topics for this morning.
Right.
So if I then turn to the next 2 points, the next one is the missing text in the minutes for the 21st of May meeting. Now we say this really is beginning to scrape the barrel. This question was fully litigated. The judgment is careful and thorough in relation to it, and none of the evidence that was supposedly overlooked is remotely significant enough to constitute a defect in the judgment justifying a filter reopening of the trial. So if you could pick it up, please, at paragraph 527 of the judgment. That should be on page 411. So at 527 through to 534, we see the judge's analysis of the meeting and his primary factual findings about it. And some points just worth picking out from here, just to draw to the court's attention, are that if we move on to paragraph 532, this is a point that has been made, I think, before, but it's important to remind ourselves in the context of this particular plea, that although EE's minute for the BRM, the Business Review meeting, is not complete, firstly, Orange produced a meeting note that was drawn up by Monsieur Deloisson, based on a discussion with Monsieur Nello, and that's at 532A sub Roman 1. And then we have Mr. Alera's own take in his email of the 23rd of May, and that's addressed at 532A Roman 2. So already we see that the spectre that's been raised by my learned friend of there being some clandestine conspiratorial meeting where everyone agreed not to write anything down because they knew how dangerous it was, it's already obviously wrong. Indeed, we saw that in Monsieur Deloisson's note, there's even a reference to antitrust risk. So the parties are plainly mindful of the need to obey the law. Now, what we said about the minutes is that in a busy world, and Mr. Harris was a busy man, he made a mistake and he failed to ultimately get the minutes written up. What Phones for You ask you to believe about the minutes is that, firstly, the first premise, of course, is that this meeting between many senior executives was one where they nakedly discussed their unlawful collusion, and then they decided that they would not document it because of the problems that would lead to.
Yeah.
Just pausing there, that allegation was never even put to Mr. Swanty, EE's CEO, at the man in charge of the meeting. Didn't bother to put that to him at trial, but that's actually what went on at the meeting. In my submission, that is an incredible omission, if this is really their case. Also, the meeting had 4 DT executives, and you'll be hearing obviously from Mr. O'Donoghue about what he says the implications of that are. Now, then Phones for You need us to believe that EE decided to engage in the cover-up by omitting the section of the meeting notes, but then Orange, who'd been party to this illegality, then decided to break ranks from that, and it decided to write its own notes. And then started perhaps ingeniously to make up things about antitrust risk as a cover for the fact that what they were really doing was engaging in a discussion of something anti-competitive. And then Mr. Alera, then we see, he's forgotten the memo that they need to destroy all the evidence, and so he starts doing emails about it. And then indeed, EE generally apparently abandons the do not document strategy by the 8th of July, because the 8th of July board meeting referred to the potential disappearance of phones for you from the mobile market in the medium term. Just for your reference, that's in the judgment 709. So I say that already this argument that one can assume that the absence of a section of the minutes is something that from which one can immediately infer that there's something nefarious going on is really pretty far-fetched. In that context, then, we need to look at the three allegedly missing elements of the evidence. And I can do that pretty briefly. So the first is the allegation that the judge failed to address Mr. Harris's evidence, which is that he had no recollection of ever failing to type up a near verbatim minute of a BRM. If we could go, please, to the judgment at 590. And could I ask the court, please, to read 590 through to 598? This is the judge's analysis of that issue.
Yeah.
So what one sees here is the judge summarises fairly the key evidence from Mr. Harris. He notes Mr. Harris's usual practice of sending a draft to the two front doors of the shareholders.
Yeah.
He notes Mr. Harris mentions his inability to explain why the two sections of the minutes were blank. And he notes his acknowledgement that it's surprising that he wasn't chased for the minutes on this occasion by shareholders. And so the court firmly and squarely appreciated that Mr. Harris's evidence was that this was out of the ordinary, but he couldn't recollect why that was the case, and he didn't think that it was supportive, ultimately, however, of there being any collusion. So it was addressed. This filter point just doesn't even get off the ground on that basis. The second justification that's given is they say, well, the judge failed to deal with Mr. Milson's evidence to similar effect. But if we go to the allegedly overlooked evidence, that's in supplementary bundle 1429. and it's on 133, lines 12 to 9, I think. So all we see is that Mr. Milson's evidence is to the same effect as Mr. Harris's, that it was very unusual. But then he also says, I can't recollect any appropriate discussions about indirect. And so we say that goes nowhere. It was not sufficiently critical, given that the analysis of Mr. Milson's own evidence, that this represents something that was a core piece of evidence that was overlooked. And then the final attempt to reopen the issue of the 21st of May minutes by my learned friend is a reference to the so-called similar fact evidence concerning Mr. Harris and the March 2014 minutes. And you may recall what was explained about this is that there was an occasion in March where the evidence was that Mr. Harris typed up his notes and then went to Mr. Blendis to examine whether they'd been inappropriately captured from a competition law point of view. But that is not a similar fact pattern. That is something which is very different. That is Mr. Harris documenting a meeting and then seeking legal advice from EE's legal team about antitrust issues. It's not choosing not to document a section of a meeting at all. So it's really far-fetched, we say, to suggest that that is sufficiently similar fact evidence that there is a built-in error in not referring to that when dealing with this issue. And as the judge found in his judgment, if we go back to the judgment then at 595, it was most unlikely that if this was a case of deliberate suppression of a conspiracy, that the indirect distribution section would not be documented at all. Something rather more sophisticated would one imagine have been done than that. And so what the judge, we say, entirely properly accepted is it may simply be that under the pressure of daily events, Mr. Harris never got round to completing the typing of the minutes.
My recollection of the document related to the March 2014 minutes was it wasn't just going to Mr. Blendis, was it? It was an expression about his concern about being conscientious about the minutes, I think. Can we see it?
Yes, we of course. So I think it's you're referring to the cross-examination.
I was referring to the similar fact evidence raised in the March 2014 minutes.
There's an email.
Yeah.
The email.
Email to Mr. Blendis, I think.
I'm going to need to get a reference, but bear with me.
Yeah.
Why don't we take a break, Mr. Pickford?
1015.
Oh, you've got it, have you? 1015.
It's also in the core supplemental bundle, my lord. I think I showed you that at page 71, core supplemental bundle.
No.
Not this one. Page 71.
It's a reference to extra courses.
That's the same one, is it?
No, this isn't it.
Just being extra cautious.
It's the one about inappropriate or appropriate from a competition
Yeah.
point of view.
Yeah, that one.
Okay, so I think that's extra cautious. Where's the inappropriate? Where's the? I think the inappropriately captured point is not. I think this is the email, and then I think what my lord may be referring to is the cross-examination.
No, I think the point was made is that the topic is indirect next steps, and at the bottom the point was made that there is Mr. Harris saying he's just being extra cautious given the topic above.
Yes.
I think the point was made that there he's being extra cautious given that topic, and then subsequently he's not even
The next time he
leaving the
doesn't
minutes
even do it.
blank.
leaves
Yes,
it blank.
but-
That was the point.
That was the point that was made.
That was a similar fact point. That on a
Right.
previous occasion he'd been cautious and asked Mr Blenders, and on the next occasion he's even more cautious by leaving it out altogether.
That was the point that was
And I
made.
think
Well,
that's the point.
My submission in relation to that is it is not a sufficiently similar fact that for the judge not to refer to it in his pretty comprehensive analysis of why he doesn't accept the phones for you submission on this does not reveal a built-up error. He can't be expected to refer to every single piece of evidence, and this is not sufficient in my submission. And of course, we obviously also heard, and the court will be aware of this, that there were sensitivities about competition risk in relation to indirect because of the merger, because that had been discussed. They were well concerned that anything that happened between Vodafone and EE, if there was ever a merger, would be a very sensitive issue. So that, I mean,
You
I'm
mean
not in a
joint
position to say.
acquisition?
You mean joint
Yeah.
acquisition?
I beg your pardon, yes, I'm calling it, yes,
Yeah.
it's a joint acquisition. So, in my submission, there is simply no built-up error here in relation to that issue. And then finally we have the ground 5 point about misleading offcom. Now, what Phones for You complain about here is that the judge addressed the question of EE having made a presentation to Ofcom that contained an error in relation to dates in a compartmentalised fashion and failed to consider the implications for his other findings. And they say he should have revisited, in particular, the question of the 21st of May notes again. Now, I say, just in passing, there is obviously a supreme irony here in this ground, because this entire ground 4 and much of this appeal involves looking at issues in an exceptionally compartmentalised manner. And what we've been seeking over the last couple of days to do is to put them in their proper context. But putting that one to one side, key issue obviously is what the judge did. And in my submission, the judge did quite the opposite of the accusation that's being levelled against him. So if we could go to his judgment on page 432. And 615.
Yeah.
And if I could ask the court to read that paragraph, please.
Yeah.
Now, he clearly turns his mind to the very issue of whether he should revisit any of his other conclusions. Now, the complaint is, but he doesn't specifically mention the incomplete minutes issue for the 21st of May. And my response to that is unreal. There were hundreds, if not thousands, of issues in this case, and it would be quite wrong for the court to engage in a huge number of alternative permutations for different types of issues that he does or doesn't think it requires him to revisit. It's perfectly acceptable to deal with it in this compendious way in this paragraph. And there is nothing more to that point. My lords, my lady, unless there's anything else I can assist.
No, I don't think so. I think it's pretty sensible if we have a break now. So if we say about...
Oh, I beg your pardon. I didn't make Mr. Williams' very helpful point that he, in answer to a question from my lady about the paragraph of Phones for You's pleading, where they say
133.
it's always going to be mutual.
Yeah.
And then at 138A of their pleading, they then do a mutatis mutandis and apply that same paragraph to everything else.
Yeah.
I beg your pardon, to 131, which is the critical one.
Yeah. Okay.
Thank you, Anne.
Well, let's take a break then. So you say about 7 minutes. So about 25 to on that clock.
All right. Yeah, of course. Okay, no, that's fine.
We got your mates to see I wouldn't mind. Yeah. The 10:30 starts are actually quite nice. Yeah. Especially if you're staying nearby, it's not too bad. No, it's not bad at all. I've done these mystery quick charm. That's all. I wouldn't mind. Yeah. It's very nice and rich. We'll see you Monday, Tuesday. If you're not in next week, I'm going to take Tuesday off. Right. Thank you for
Yes. Extraordinary. Presumption. Online.
Where's David does this? Doesn't matter. It's too strong.
Before and after.
In one go with a late from 1:30 to 1:01. That's the way the timetable. Yeah.
Okay.
Is all ready? All rise, people.
Hello, it's my lady. I'm going to deal now with round 7, which relates to document preservation. The document preservation issues relate only to the 2 Spanish Telefonica companies. There were no document preservation issues in relation to O2. As recorded at paragraph 60 of the judgment, both Telefonica defendants apologised to the court for not adopting broader document preservation issues. I'm not here to justify their conduct. They've accepted they didn't do what they should have done and they've apologised for it. And the judge recognised that failure by reducing the cost to which the Telefonica defendants would otherwise have been entitled by 50%. So he sanctioned them in that regard. I think it is, though, important, given the aphobic principles we're going to come to point out that this was not a total failure on the part of the Telefonica defendants. A large number of documents held by Mr. Alierta and Ms. Castillo were preserved and disclosed as appropriate. And we explained that in our trial skeleton. I'm not going to take you to it now, I'll give you the reference. We explained what was done at paragraphs 28 to 36 of that trial skeleton. That's supplemental bundle 2, tab 26, at page 582. But just to summarise, the broad picture is, because of what was done, the likelihood is that all of Ms. Castillo's emails were preserved. In fact, 78,361 of Mr. Alierta's emails were preserved. And the reason that the number of such emails that were actually disclosed is quite low is simply because they weren't relevant. Because the high-ranking company officers in the Spanish parent companies were not concerned on a daily basis with the UK market, let alone issues relating to phones for you. It just wasn't within their remit. So that's why, in opening, Phones for You made the point there weren't many documents disclosed. It's because they just weren't relevant because of the nature of the individuals involved. In relation to applicable legal principles, any dispute between us has now gone as a result of Mr. Draper's submissions in opening. There is now agreement that the relevant principles are those set out by Lord Leggett in the Aphobe case. If we can look briefly at that, that's Authorities Bundle 6, tab 28, page 1338. You see, it's a judgment of the Supreme Court of 2021, and I'd like to go to page 1351.
And if I could ask you to read paragraphs 41 to 43, this is where Lord Leggett sets out the appropriate quote. And although this was a case concerning witnesses not attending, it's now common ground between us that this approach also applies to lack of documents. And as Mr Draper referred you to in opening, that's the Volpe and Volpe case in the Court of Appeal, and it's Lord Justice Lewis. And there's no dispute now between us on that issue. Phones for You says that the judge failed to take into account that Telefonica's failings in respect of document preservation were the result of deliberate decisions by Telefonica. But that is not correct. Deliberate can mean different things in this context, and there is a good discussion, a very helpful discussion of this in Mr Hollander's book, Authorities Bundle 18, tab 69. This is obviously a very well-known work in the field. If we go over the page to 4092, you'll see that this is the 15th edition, published in 2024, so this is the most up-to-date edition.
Yeah.
Now if we can go to page 4130, and I invite you to read the first paragraph under the heading Adverse Inferences Discussion. And I'll come to this in a minute. As we'll see, the judge found that this wasn't, if you like, a Hollander Category 1 failure, in the sense that Telefonica identified incriminating documents and then destroyed them. It was a Category 3 failure, in the sense that there was a deliberate decision taken not to preserve them. If we can go to the judgment next, so Core Bundle 18 at page 276. And if I could ask you to read paragraphs 57 to 59.
Yep.
Now, if I could emphasise 3 points. First of all, in paragraph 57, the judge records that Telefonica explained that it took a deliberate decision not to adopt document preservation measures. And that is, as we'll see, the basis upon which the judge decided whether to draw adverse inferences. Paragraph 59, the judge applied the aphobia principles. And also, the final sentence of paragraph 59, the judge found that he was not justified in finding that incriminating documents were deliberately destroyed, i.e. Mr. Hollander's first category. So the judgment found that Telefonica did not identify incriminating documents and then deliberately destroy them, but he clearly proceeded on the ground that Telefonica had taken a deliberate decision not to adopt sufficient document preservation measures. It's the Hollander category 3. And it's also clear that the judge did not consider that this prevented him from having the power to draw adverse inferences. It's simply the case that he did not consider that it was appropriate to draw adverse inferences in this case. If we go to page 347 of the judgment, and I'd ask you to read paragraph 303. So you'll see from that that the judge's decision on whether to draw adverse inferences was taken on the basis that the conduct in this respect by Telefonica showed an arrogant disregard of the seriousness of the allegation being made. In other words, it was made on the basis that Telefonica had taken a deliberate decision, an arrogant decision, not to adopt appropriate document preservation measures. But as you see, the judge found that it was not appropriate to draw any adverse inferences in the case for the reasons that he gives in paragraph 303
his thinking was clearly
of the judgment.
Insofar as there was communication by Telefonica to O2, it would be captured by the O2 disclosure. Insofar as there was any communication with Mr. Kalau, that would be captured by Vodafone disclosure. And presumably, I mean, he doesn't spell it out, but his thinking would be more, is it really likely that there were lots of internal documents within Spain that didn't go anywhere else that would have been incriminating? Especially found that they haven't deliberately weeded out those documents, then you might agree with him or not agree with him, but the issue is that he's entitled to reach that conclusion.
That's right. And one of the sort of subsidiary points that FONSView makes is to the fact that Telefonica's document preservation failures were not limited to Mr. Alerta. It was a more general failure than that. But as the court is no doubt aware, we saw it in Aphobia a minute ago, actually, is probably the best authority for this. Where a party seeks to rely on an adverse evidential inference, it is necessary for it to set out clearly the point on which the inference is sought. You can't just at large say there's been a failure and then seek to sort of navigate through the trial. And the reason why the judgment focuses on Mr. Alerta is because that was FONSView's case on adverse inferences in its closing submissions. And FONSView can't now on appeal suddenly make a general point. It's stuck with the specific submissions it made in relation to adverse inferences at trial and those related to Mr. Alerta. So just to summarise where we are on this, in deciding not to draw any adverse inferences, the judge applied the correct legal test, phobia, and he took into account relevant factors in reaching that decision. And Lord, as you just said to me, there is therefore no basis for overturning that decision. Now there was a secondary argument that was put in the opening submissions, which is that the judge wrongly relied on a lack of documentary evidence in his judgment. So it's sort of that the judge positively relied on a lack of evidence, and that was unfair given the document preservation issue. Now, the sole example that's put forward in support of that argument relates to paragraph 133 and 138 of the judgment. If you go to page 300. Paragraph 133, and it's the final email that's referred to there. Mr. Maple's brief email acknowledgement included the remark, One issue which I don't wish to lose sight of is that this is currently a unilateral move. Presumably the region can guide us as to whether there is a broader appetite for change. And that was an internal O2 email sent by Mr Maple, who we've already seen was an O2 employee. And then if we go to paragraph 138 on page 302, if I could ask you to read that, please. I'd like to make 2 points in relation to that. First of all, the judge's reference to a lack of subsequent internal documents was only one of the reasons relied upon for this conclusion. And the second point, again, my lord, as you just pointed out to me, reminded me that O2 had given disclosure.
Well, surely is what he's really got in mind, the internal O2 document, isn't it?
That's right.
Because there would have to be communication would have to have come from Telefonica to O2.
That's right. Well, it's either, he's making the point, you'd have seen something in O2. If Telefonica had sent something, it had been caught by the O2 disclosure, if there'd been internal O2 disclosure. Again, it's all within absolute what the judge was reasonably entitled to find. But the way the secondary point is put, the suggestion that the judgment as a whole, or any particular part of it, is undermined by the judge positively relying on lack of documents when lack of document resolution just doesn't stand up. This is the only example that's given. Even if there are other examples, this is the best example that's given, and it just doesn't bear out that secondary allegation.
Okay.
So unless you have any questions, that's what I wish to say in relation to document resolution.
Thank you. Thank you. Yes.
Lord, my lady, just to orient myself on the balance of counsel, I appear on behalf of Deutsche Telekom DT.
Yes.
I will be followed by Mr Bailey on behalf of the CMA, and then we're into Mr Bailey's reply.
Yes.
And there's the possibility of reply by the other respondents.
Now, how long are you going to need? There was some suggestion that we sit to 1:15 and only have a 45-minute lunch break. Is that what we've got?
Expedite things in the 45. I think I would need about 20 minutes.
Okay.
At the moment, I would estimate 45 minutes, but I'm very happy if the court would prefer.
Well, I'm only asking because obviously it's. I mean, if you think we only need a 45-minute lunch break because we need to finish, then we'll do that. But unless we're normally trying to take an hour for all sorts of reasons.
Yes.
All right. Anyway, let's get going.
Let's see how we go. So, ladies, just to recap, DT was until 2016 a 50% shareholder in EE, the other shareholder being Orange, and both DT and Orange divested their respective shareholdings in EE in 2016. So the case is to a good extent of historical significance for DT, albeit still of considerable significance. I have 3 short points.
What happened to EE as a matter of interest thereafter?
It was purchased by BT.
It was purchased by BT.
Yes. And to complete the corporate picture, DT retains, I think, a 12% stake in BT today.
And it's gone off somewhere else.
Yes. Yeah. Well, 3 short points today. First, there has been a concession by Phones for You following their appellant's notice that they do not seek to establish any involvement in wrongdoing by DT. I want to show you the concession and explain the immediate implication of that. Second, there is a wider implication of the concession that I want to briefly. Then finally, I want to respond in no more than 1 minute to Mr McLean's submission that a supplemental skeleton should not be admitted. Set this out in writing. I don't propose to the greatest hits of all set in writing. Point. On the concession, I'll show you the concession shortly, but the context, my lords and my lady, of concession is that it is the culmination of a continuous retreat by Phones for You in its case against DT's involvement in collusion, to the point now of complete abandonment of that case today. The case against DT was put into ways in terms of liability. First, there was an allegation that DT was directly involved in collusion. That was put in two slightly different ways. The first was that DT itself was involved in collusion, discussions with other undertakings. The second was that regardless of whether DT was itself involved in collusive discussions, it was at least made aware of collusive discussions by Orange and or EE, and so was directly responsible in any event. So that's the so-called direct case. There was also an allegation that even if the DT was not directly involved in collusion, it was still indirectly liable as one of the two former 50% shareholders of EE. This is the well-known single undertaking point, the competition law, which, as your lordship and ladyship will almost certainly be aware, does not depend on participation or indeed even knowledge of the infringement. It's essentially a vicarious form of liability dependent on decisive control of another infringing entity. And the trial judge found at 640B that the single undertaking liability applies without participation or knowledge. It is, in a sense, a strict, or relatively strict, form of liability based on common ownership. Now, my lords and ladies, we don't need to concern ourselves today with the single undertaking route to liability. That forms no part of the appeal. On the direct case, which is what I want to touch on briefly, Phones for You sought extremely onerous disclosure from DT and indeed the other respondents, including personal emails and personal devices of DT's CEO, CFO, and multiple board members. No stone was left unturned in this litigation. And all of these senior DT executives, including the current CEO, former CFO, and several board members, then had to traipse to London to give evidence at trial. But at trial, there was an effective collapse of Phones for You's case of direct involvement in collusion by DT. The suggestion in the pleading that DT coordinated with other undertakings at a European parent company level was not even mentioned at trial in the case of DT, and the case that DT was not itself directly involved in collusive activities or was made aware of collusion by Orange and EE was also effectively abandoned at trial. It wasn't put at all to many DT witnesses, or certainly adequately. And it is accordingly entirely unsurprising in this case that all allegations of direct wrongdoing by DT were rejected in full by the learned judge. However, DT remains a party to the appeal. The case has not been discontinued against DT. As your lords and ladyship will be aware, we did put in a respondent's notice on a precautionary basis. We explained in the skeleton accompanying that document that we did not perceive, based on the appellant's notice, that Phones for You had raised any ground of appeal that would undermine the judge's findings, exonerating DT of involvement in collusion, and so we did not understand Phones for You to be advancing through its appeal any case that DT itself had involvement in collusion, but the respondent's notice was filed in the event that that understanding was incorrect. So that's the context, my lords and my lady. Now, with that preamble, can I show you the concession itself? We can pick this up in two places. First, it is in the supplemental skeleton in September of last year. That's in core bundle, tab 9, 199. And it's in paragraph 5, about 2/3 of the way down. It says, first, the notice, being the respondent's notice, argues that it is not open to Phones for You to contend on appeal that DT is directly liable for breach of competition law, such liability being distinct from DT's liability if he is liable as part of the single undertaking. Now, pausing there parenthetically, that is the indirect case which we can park for purposes of today. And they go on, but DT knows the appeal does not contend that DT is directly liable. He says correctly, none of the arguments Phillips now makes in its appeal concerns DT such that its respondent's notice does not arise. Now, there was an accompanying letter, I think on the same day, around the same time, supplemental 139-1544, please.
Yeah.
From Phone's solicitors, and it's a paragraph 2 months.
It's not phones for use. Oh, forgive me.
Yeah.
The appeal does not seek to challenge the judge's findings. The DT was not directly liable for breaches of competition. So there we have it. After many years, the white flag has now finally been raised in the direct case against DT. The direct case against DT dead by virtue of this concession. Now, just then to move on to my 3 quick points. In terms of the immediate consequence of the concession, there are two basic solutions. One is the immediate or direct consequence of the concessions we've just seen, and second is a couple of wider consequences for this appeal. The first point is a short one. In the light of the concession, it is simply not open to Phillips to suggest either that DT itself engaged in improper collusive activities, or that DT was even made aware of collusive approaches to Vodafone by Orange and or EE. So that aspect of the case is dead. And whatever else happens in this appeal, it cannot be revived or reopened if there was to be any remittal. And the trial judge dismissed the direct case against DT in all of its permutations as advanced, and so is res judicata and has not been appealed. So that is the short and direct consequence of the concession. Second, in terms of the wider implications, we make 2 points. Our basic point is that the concession necessarily also means that important aspects of the case that Phones retains against Orange and EE become either unsustainable or at best incoherent. Now, just to give you a couple of examples, the first dovetails with the point Mr. Pickford addressed you on this morning, the BOM meeting of the 21st of May 2014. And the court heard a great deal from Mr. McLean about this particular meeting, and he said, in effect, this is a crucial meeting revealing anti-competitive collusion, and he goes further. He says that in addition, the collusive discussions evidence of that meeting were deliberately covered up by the minutes appearing blank. Now, Mr. Pickford responded to that point this morning, and we respectfully adopt his submissions. There is a further important adjunct to this point, given the concession I've shown the court. The BRM in question was attended by no less than 4 representatives of DT, including its CFO, Mr. Dannenfeld. Now, just to show the court what the trial judge said about Mr. Dannenfeld, we can pick this up in the judgment at 484C, Core Bundle 18397. 484C. Mr. Justice Roth says, I was impressed by Mr. Dannenfeld, the witness, by publicly frank his evidence of the times of technology. I accept his testimony that if someone had said at this meeting that there had been such potentially anti-competitive discussions because of the legal implications, this is something which would have stuck in his memory. And this, as I indicated, is unchallenged by Phones for You.
Yeah.
Now, in relation to the BRM specifically, Mr. Dannenfeld was, as I indicated, in attendance together with 3 other GT executives and personnel. And if we then go to paragraph 533 of the judgment, 414, you will recall that Mr. Pickford addressed you at some length. So the context, my lords, related, just to recap, is that this is a near contemporaneous note from Mr. Deloison of the BRM, the 21st of May. And the bit I'm interested in terms of Mr. Dannenfeld, the impressive witness noted by the trial judge, you will see in the middle, or about 3 lines down, Mr. Dannenfeld, be careful with Vodafone antitrust risk. And then if your lordship, your ladyship can then read the rest of the paragraph, what the trial judge finds in a nutshell is that that reference to antitrust was a perfectly legitimate remark by Mr. Dannenfeld that if the matter proceeded to a joint acquisition of Phones for You, there needed to be a protocol in place for this to be conducted in a particular manner. So all of the judge's findings concerning Mr. Dannenfeld are unchallenged. And this particular finding, it is very significant because it goes to the wider allegations of collusion grounds 4 and 5. And given that the judge's findings in relation to Mr. Dannenfeld, in relation to this particular meeting, are unchallenged, Phones for You's case, in my respectful submission, then becomes incoherent. Because what one then has is a witness that the judge found was impressive and frank in relation to a party of which 3 other attendees at the meeting were present, where the judge records at 533 this was a legitimate discussion in part to do with a joint acquisition. And the remarks made by Mr. Dannenfeld were not only not inappropriate, but were an entirely appropriate reference to a need to be have a protocol in relation to a joint acquisition scenario if that materialized. But we say, in relation to the BRM, this puts beyond question that the discussion at that meeting, as evidence in this contemporaneous note and the evidence of Mr. Dannenfeld, was entirely legitimate and is evidenced by near contemporaneous material. And in my respectful submission, in the light of Mr. Dannenfeld's characterization by the judge and the findings at 533, we don't even get to the question of suppression of the minutes to do with the indirect component. You have a clear finding based on Mr. Dannenfeld in 533 that what was discussed at that meeting was entirely above board, so far as it addressed indirect concerned a joint acquisition, in which Mr. Dannenfeld, among others, was behaving entirely appropriately and indeed actively raising the need to observe correct protocols. So in fact, it is a fortiori. So the suppression point of respect doesn't go anywhere. And indeed, there is a broader point in relation to Phones for You's entire story in 2014. The concession that Phones for You has made in relation to Deutsche Telekom makes the retained case against the other respondents all the more curious and, we say, incoherent, because if Deutsche Telekom is not accused of direct collusion in any shape or form, the case theory for the other respondents in 2014 becomes very odd indeed. It must inevitably mean that Phones for You is now running a case that Orange or EE colluded with Vodafone, but at the same time somehow kept this concealed from DT. And Phones for You have never explained how this modified case might have worked. That is not the way Phones for You advances case at any stage, and yet that is the case apparently Mr. McLean invites the court to remit to the High Court. So that is what I wanted to say on the 21st of May, BRM. In relation, my second point, this is my penultimate point, the court will recall, I think on day 2, there was a passing reference by Mr. McLean to Ms. Claudia Neymat, discussion with Ms. Ava Castillo, and Mr. Hoskins, I think on day 3, also addressed you on that. And I respectfully adopt Mr. Hoskins' submissions. He made 3 points. First, there is a note of this call, there is no secret here. Second, the note does not show that the discussion was inappropriate in any way. And third, the discussion in any event has nothing to do with allegations of collusion involving phones in this case. We have one coda to add to that, and it is a question of fairness to Ms. Claimant. She was not cross-examined on the note of the meeting on the 7th of October with Ms. Castillo, because the note in question only emerged in terms of disclosure following Ms. Claimant's cross-examination, as indeed Mr. Claimant fairly concedes in footnote 2 his supplement. So we say, in any event, in addition to the points Mr. Hoskins made, it would be quite unfair to Ms. Claimant to make any findings in relation to that particular discussion. Well, Lord Milady, finally, on the question of the supplemental skeleton, we've addressed Mr. McLean's objections in detail in writing with the supplemental bundle, tab 140, page 1553. Now, I don't propose to give you a greatest hits of what is set out there. Let me make the following, which is the nutshell of what we say. Our submission is that our supplemental skeleton is not a respondent notice point, because the supplemental skeleton demonstrates that PhoneFu's own grounds of appeal are flawed. The skeleton is directly responsive to their appeal. It is not seeking to uphold the trial judge's conclusions for different reasons. So we say it is entirely appropriate for those to be addressed by way of supplemental skeleton. Lord Milady, those are DT submissions.
Thank you very much.
Yes. Yes, the letter is at page, tab 147, page 156.
15.
Lydia, unless I can further.
No. Thank you very much, Mr. Avery. Yes.
May it please the Court. I appear on behalf of the CMA, and it has intervened in relation to grounds 1 and 2. I propose to structure my submissions in 4 parts. First, briefly to draw the Court's attention to 2 further authorities on concerted practices. Second, Mr. Dunn remarks at the landmark lunch. Third, Mr. Swanty's response. And fourth, the CMA's position in relation to ground 2A to 2C in relation to the Anic presumption of a causal connection. Now, the Court has been shown various authorities. If I may, I'd like to show the Court one more case that you have not yet seen. Can we go, please, to the authorities bundle, volume 5, at tab 17. This is a judgment of the Competition Appeal Tribunal, chaired by Mrs. Justice Rose, as she then was. And if we can pick it up, please, at page 911. Here, the tribunal is setting out its understanding of the relevant law. And we can see in paragraph 37, it sets out the classic definition of a concerted practice. If I could draw the Court's attention to 3 points in particular, starting at paragraph 38, you'll see here the tribunal explains that many of the later EU cases concerning exchange of confidential information explain the borderline between permissible and impermissible conduct by citing the passage in the sugar cartel, the TFEU case, to which your attention was drawn on Monday. Of course, that case dates back to 1975, but in my submission, it remains good law. Over the page, the tribunal makes, in my submission, a really important point. The European courts have emphasised that one key aspect of the concept of a concerted practice is that in a properly functioning competitive market, competitors should not know how their competitors are likely to behave. A reduction in that uncertainty is a key part of the concept of a concerted practice. And you can see, my lords, my lady, the quotation there to the cement case with which you are familiar. The following paragraph 40 refers to the Anic case, my third and final point on this judgment is at paragraph 41. We can see here the tribunal is referring to the strictness of the law in this regard, having just referred to Anic, that it is hard to think of any legitimate reason why competitors should sit together and discuss prices at all. And you can then see a passage from the JJB Sports case that is referred to. Now, of course, here, the tribunal is focused on the dangers of discussing prices. But in my submission, competition concerns are not limited to information on pricing. They can arise whenever competitors discuss or disclose information that reduces uncertainty as to the operation of the market. And if I may, to make good that point, can I take the court, please, to the European Commission's guidelines that are to be found in the authorities bundle at volume 17 at tab 65 at page 3734. Thank you. And it's paragraph 385. We can see here the Commission echoing the tribunal that information on pricing is generally considered commercially sensitive. But could I ask my lords, my lady, to read what the Commission goes on to say in the rest of that paragraph, please? I do make 2 points about that. The first is that the court can see the wide range of information that can be commercially sensitive. But of course, that's a question of fact to be considered in each case. And the second is the point made by the Commission in the final sentence, that the information conveyed does not have to be true or accurate, provided always that it is reducing or removing uncertainty as to the conduct of competitors on the market. For the court's note, the tribunal itself made that point in paragraph 95 of its judgment in Balmoral Tanks, Authorities, tab 17, page 936. No need to turn it up.
95.
Paragraph 95, my lord, yes. And if I may, just before moving on from the guidelines, just draw the court's attention to a further passage, which in my submission is helpful, and that's at page 3736, under the heading Unilateral Disclosure. It's paragraph 396. It's been sidebarred.
Sorry, I'm sorry.
I apologise, my lord.
What is it that 95 demonstrates?
Paragraph 95 is making the same point, my lord, about the information that's conveyed doesn't need to be true or accurate,
yeah, sorry, yes, I got
provided it reduces or removes uncertainty.
Right.
The point being made by the Commission in paragraph 396 is it's dealing with unilateral disclosure. We can see here in the first sentence, echoing really the General Court's judgment in Cement, that where one undertaking discloses commercially sensitive information to a competitor, which either requested or at the very least accepts it, that can constitute a concerted practice where this competitor acts upon such a disclosure, and provided there's a link of cause and effect between the disclosure and the competitor's subsequent conduct. And then this, where one undertaking alone discloses commercially sensitive information to its competitors, this reduces strategic uncertainty as to the future operation of the market for those competitors. And we just asked the court to note that here the Commission footnotes at footnote 259 an opinion of Advocate General Cocotte in the T-Mobile case, paragraph 54, and I will show the court that opinion in due course. I'm just noting it for the time being. I propose to move on to my second issue, and that is what Mr Dunn said during the landmark lunch. Now, the CMA has approached this issue mindful of 2 points. First, as Lord Justice Lewison observed in Volpe and Volpe, an appeal court should not subject a judgment to a narrow textual analysis, nor should it be picked over and construed as if it were a piece of legislation. That's at paragraph 2, Authorities, tab 31, page 1454, and that's well established. The second point is that so far as the CMA is concerned, it was not at the trial. It has not seen all the evidence that was placed before the judge, and of course for that reason it does not wish to second guess any of the judge's findings of fact. So I therefore propose to proceed in 3 steps. First, I'll briefly address the judge's approach to how he analysed Mr Dunn's remarks. Second, I'll very briefly respond to the specific legal errors of law alleged by Phones for You in writing. And then third, I'll respond to how Phones for You put its case on Monday, and more importantly, how the court has expressed a concern about potential inconsistency between the findings in paragraph 197 and the findings in paragraph 217 of the judgment. If I can turn then first of all to the legal test for whether a communication from one competitor to another is capable of giving rise to consultation, could I ask the court please to turn up the judgment in the core bundle at tab 18 at page 320, where one sees the judge set out his approach at paragraph 205. Respectfully, the CMA agrees with the final sentence of that paragraph. It also endorses the book that's referred to beforehand, but more importantly, for these purposes, you can see that the judge essentially makes 3 points. First, his approach properly reflects the concern that we saw in Balmoral tanks about removing or reducing uncertainty. Indeed, you can see that echoed in the judgment quoted at the top of page 320. That's from Claimant, the copper fittings cartel. Second, we respectfully agree with the judge that the question is whether the information disclosed is sufficient to remove, or the CMA would interpolate, reduce uncertainty. If I pause there for a moment, on Wednesday, Telefonica's submissions, day 3, page 64, suggested that there's a need for a certain amount of specificity for the information to remove or reduce uncertainty on the market. For the CMA's part, it would agree that the degree of precision may be relevant in some cases as to whether it reduces or removes uncertainty. In HSBC, the case cited by Telefonica is an example of that. The CMA disagrees, however, that the law always requires that the information imparted needs to be specific or precise. As my Lord Justice Phillips observed on Wednesday, the test is not about the specificity of the information. The test is rather about, did it remove or reduce uncertainty on the market? And indeed, the judge appears, in my submission, correctly to have recognised that in paragraph 197.
Yeah.
And we see that where he talks at the very end, this is on page 317, that Mr Dunn didn't spell out in clear terms, but there was an invitation to collude, and there's no need for precision specificity if, as here, Mr Swanty clearly understood the message that his competitor was conveying.
And he finds elsewhere that Mr Swanty clearly did understand.
Indeed, my Lord, and he makes that finding in 197 and echoes that finding in 199, which I'll come shortly. The third point, if I may, just on 205, is that the judge says there that the recipient needs to be put in a favourable position. Just to make clear, the CMA's understanding of that is that by favourable position, we understand the judge to mean that the recipient's uncertainty has been removed or reduced. We don't understand the judge to be saying that it needs to be shown that the recipient is somehow commercially better off. If I turn secondly to the errors alleged by Phones for You, as my Lord Justice Phillips pointed out on Monday, the judge sets out his conclusions in 2 places. We see those at paragraph 208, and that's at page 321. And he there deals with part of what Mr Dunn says in terms of playing big cards and unilateral steps. And we can see that his conclusion is those don't remove uncertainty in EE. Now, Phones for You have said that it is an error to interpret the phrase benefited EE as if it imposed an additional legal requirement. Well, we agree that if there were such a requirement, it would be wrong as a matter of law. But as my lords and my lady, you will have gathered, the CMA doesn't read this in the way that Phones for You allege. We read it to mean that it didn't put, according to the judge's finding, EE in a position because its uncertainty had been removed. The other place where the judge sets out his conclusions, as the court is well aware, is in 217, and that's to be found on page 324. And the court is very familiar with this passage, and all I will say on this is that the CMA does not agree with Phones for You that this paragraph is in some way requiring some form of positive support from EE in order for there to be consultation. If there were such a requirement, it would be wrong in law. That is not how the CMA reads the paragraph. Now, my third step seeks to respond to how Phones for You put a broader submission on day 1, page 30, and zoomed in on the finding made in paragraph 197 of the judgment. And I'm conscious that my Lord the Chancellor also identified a potential inconsistency between the last 2 sentences of 197 and the last sentence of 217.
Yes.
Now, the CMA refrained from commenting on the legal characterisation of the facts in its written observations. We focused on the errors being alleged by Phones for You. We're, of course, an intervener, but I do hope it will assist the court if I set out the CMA's view of what the judge actually found in paragraphs 197 to 200. And it appears to be common ground, as my learned friend for Telefonica addressed the court, those paragraphs find the primary facts.
Yes.
Now, on Wednesday, the Chancellor asked EE, it's day 3, page 93, whether the only evidence other than the witness's recollection 10 years after the event was Mr Blendus's email of the 25th of October. And EE said that was the position. May I just refer the court, please, to what the judge says in paragraph 194 on page 316.
Yeah.
And we can see here that the judge says the nearest to a contemporary account of the landmark lunch conversation in the email from Mr Blendus of 25th of October 2012, that's the one that was referred to on Wednesday, but then he goes on to say, and then his further script drafted on the 30th of November 2012 in preparation for his meetings with his counterparts at O2 and Vodafone. Now, my lords, you were shown that draft script by Phones for You, but may I also just take you back to it briefly, if I may, because so far as the CMA is concerned, it is an important part of, as the Chancellor observed, part of the jigsaw puzzle.
Yeah.
The draft script is set out in paragraph 180, or at least part of it is, on page 313. And could I ask the court, please, to read what is said here by EE's General Counsel at the time?
Yeah.
So this contemporaneous document is telling in my submission, because what it shows is that EE itself regarded at the time that in the last sentence, O2's willingness to play some big cards, which we know is what Mr Dunn is found to have said at the landmark lunch, would be otherwise regarded as highly sensitive and confidential to the O2 business. Because we read the 2 sentences together, the latter is an example of the concern that's being expressed about the communications made by O2 about matters that are highly sensitive and confidential. Now, my lords, my lady, if we take that in mind and go back to paragraph 197 on page 317, the judge makes a clear finding halfway down that Mr Dunn was sounding out Mr Swanty to see whether if O2 reduced reliance on the indirect channel, EE might support that move to preserve value in the market. Well, the CMA's view of that is that that does constitute a disclosure of commercially sensitive information that would have reduced an uncertainty in EE as to the conduct O2 was contemplating on the market.
Well, in effect, if the effect of the last two sentences in that paragraph, as I think I said the other day,
You did, Mark.
is that is what he was doing. So it was sensitive and confidential, sounding him out as to whether if O2 reduced its reliance on the indirect channel, he would support that. And that was understood by Mr Swanty. So whatever sort of verbal flaffer there was from Mr Dunn, and however verbose he was, that's what Mr Swanty understood.
If I may say so, exactly right, my lord.
Yeah.
The CMA agrees with that.
Yeah.
And one can see that, moreover, I don't think we need to turn to it, because you've seen it before, in paragraph 199, page 318, the point is being made. But there is no doubt that Mr Swanty correctly understood the thrust of Mr Dunn's remarks, and he's referring there to O2's provisional decision to exit from Phones for You. He may not have name-checked Phones for You. He may not have said that they were exiting, but the thrust was clear. The thrust was that he was going to pull some volume from the indirect channels, and he wanted to de-risk that decision. My lords, my lady, if one goes back, and I apologise going back and forward, but I hope it's helpful to sort of see the overall picture. Go back in page 317, just to look at the reasons that the judge gave for the conclusion he reached in 197, and specifically, for these purposes, in subparagraph A. We can see here that the judge refers to the provisional decision of O2 some days before. This is all part of the factual matrix or the context of this lunch. And then what the judge goes on to say is that Mr Dunn was well aware of the concern expressed within O2 about the potential adverse effect on O2 of such an exit if the other M&Os took up all the volume. That was what the prisoner's dilemma being referred to on Monday. And then this, that if Mr Dunn had been able to de-risk, and my submission what follows is very important, as Mr Swanty notably saw it at the time, that eventuality, in other words, the risk the other M&Os would take up the volumes in the indirect channel, it would have given a valuable boost to this strategy. And my lords, my lady, it was said on Wednesday that the information conveyed at the landmark lunch was not strategic. But the judge finds in terms that the very strategy which Mr Swanty understood Mr Dunn to be referring to is one of a strategic and sensitive nature. And we saw from the draft script of Mr Blendis in November, which the judge found to be a contemporaneous record, that this was sensitive information as he understood it. My lords, my lady, I did say that I would take you to the T-Mobile case, another case involving mobile phone operators. Can I just show you a passage which in my submission is helpful when seeking to interpret what was said at this lunch? It's Authorities, tab 44, at page 2596. And this is the Advocate General's opinion. And it's paragraph 54.
Advocate General Cockott.
Yes, my lord. And what we see the Advocate General say here is that it's irrelevant whether only one undertaking unilaterally informs its competitors of its intended market behaviour, or whether all participating undertakings inform each other of their respective deliberations or intentions. And it doesn't have to give rise to an agreement or a concurrence of wills. We can see what actually is required. When one undertaking alone breaks cover and reveals to its competitors confidential information concerning its future commercial policy, that reduces for all participants uncertainty as to the future operation of the market, and here's the real competition policy concern, that there is a risk of a diminution in competition and of collusive behaviour between them. So the CMA's reading of what the judge found as a matter of primary fact in 197 to 199 is that Mr Dunn broke cover, and according to EE's own contemporaneous record, he revealed to one of O2's competitors confidential and sensitive information concerning O2's future commercial policy, how O2 was contemplating a reduction in reliance on the indirect channel, and the judge found that Mr Swanty correctly understood this. If we go back to the key aspect of a concerted practice, competitors should not know how their competitors are likely to behave. And so, in my submission, if the court considers that the judge's finding of primary fact in 197 to 199 are to be considered on their own terms, then the CMA considers that Mr Dunn's remarks did, at the very least, reduce uncertainty in EE as to how O2 was contemplating to behave on the market. Now, the CMA hadn't understood Phones for You to be appealing on the basis of inconsistent and irreconcilable findings of fact. And as an intervener, CMA didn't consider that it should be identifying additional errors in terms of how it reads the judgment.
No.
But in light of the, in my submission, correct concerns identified by the court, I hope it assists in construing the judgment that that is the CMA's view of what the judge
I'm really
found.
sorry to rise, but I don't want to interrupt you from hearing from the CMA. I have two problems with this, and they're fundamental problems. There was no indication in any of the CMA's written materials prior to this appeal that this was the CMA's stance. So, regardless of how it's come about, on an incredibly important issue, we're being ambushed. The second point in relation to this is that the function of the CMA in an intervention is to assist the court on matters of law.
Yeah. Well, I'm slightly troubled that Mr Bailey's gone further than he should, but I suppose it would be said it could be said against you that he could simply have given Mr McLean as it were, a private note, and Mr McLean could have made the points in reply.
Well, with respect, my lord, that's not possible because the CMA, as a regulatory body, cannot interfere in private litigation that way. So that is not a possibility.
Well, I suppose that is true. Yes.
We're not allowed.
No.
So I can't discuss the case with Mr Bailey,
No.
Mr McLean. But this really is it's not way beyond what's envisaged by the practice direction. It's inconsistent with the practice direction, and it's inappropriate. We've been through, whichever it was, a 10-week trial. We've been through 5 days of an appeal, and suddenly this is put in by an intervener, and it's not an appropriate intervention. And I do say that all of the submissions that have been made, which go beyond simply what the law is, are inadmissible. And so you should put out of your mind what has been said, and you should not allow any further submissions on this vein. I sat on my hands for obvious reasons, but it just got to a stage where we couldn't let this.
Well, it's very difficult for you, from your perspective, to know when to stand up and interrupt, really, isn't it? Because until you've seen the, as it were, the colour of the point that's being made, it's.
When it comes to a submission,
I fully understand the point you made.
Can I also say, I asked Mr McLean on Monday, I thought the appeal was being put on the basis of the comfort that O2 is said to have taken from EE. Now, I know we were addressed on the other direction, but I thought it was on the premise that undermined the way the appeal was being put. What we're now hearing from is nothing to do with my understanding of the way Phones for You put its appeal.
I mean, what surprised me in the last 10 minutes, if I can put it that way, maybe it's a bit less than that, is that what Mr Bailey seemed to be focusing on is EE rather than O2. So I had thought that where we were was that what because we pressed very hard on this point, and this is the point that troubled all the members of the court about, if you like, reciprocality. Is it enough if O2 leave the meeting if Mr Dunn leaves the meeting with comfort, or does it have to be EE that gets the comfort out of it? And that's what we've been addressed about really throughout.
I think Mr Pickford probably wants to row in behind me.
Maybe
there are more surprises to be had to do.
I very much do. I think between me and Mr Hoskins, we've been wanting to, when one of us is going to stand up, and he got in there first.
Yeah, okay.
We wholeheartedly endorse what Mr Hoskins said. This is, I'm afraid to say, and I regret to say, a wholly inappropriate intervention by the CMA, and we thoroughly object to it.
Well, it did seem to me it was verging towards the CMA saying, well, you should be finding that there was anti-competitive conduct.
Yes, and
which isn't their function.
And it's a complete ambush.
That's what the law is, yes, but
in relation to the issues that we thought that we were focusing on, we simply can't. This is not what I considered I was going to be responding to this afternoon. So I'm afraid it's
if I may respond to what is being said against the CMA, I made very clear what the CMA's position was in relation to the particular errors alleged by Phones for You. If I may take perhaps my Lady Justice Falk's point about the clarification on Monday that Phones for You were focusing more on the transmission of information from. Yes, my lady. But of course, as my Lord Justice Phillips observed on Wednesday, the vagueness or otherwise of the original communication is two sides of the same coin in terms of what information you get back from Mr. Swanty. And actually, if the defendants are right to say that Mr. Dunn's remarks were wholly vague such that they didn't remove uncertainty, what I was going to go on to submit is that the defendants are also right to say that silence in those circumstances cannot give rise to consultation. And so, in other words, in order for ground one to arise, in my submission, one does have to grapple with, as indeed the defendants did on Wednesday, the nature of Mr. Dunn's remarks. I should also like to make clear that the CMA was simply seeking to assist the court in seeking to construe the judgment in light of the concerns raised by the bench this week about the potential inconsistency in the judgment.
Yeah, well, that's fine, and it may be that you've slightly oversight. I don't want to be critical, speaking for myself, because you're here as an intervener and you're doing your best to assist the court. But I think you probably better leave things where they are and move on.
I'm very happy to do that, my lord. I was going to turn then to the third issue of passivity, and very briefly go through the three possible responses that were identified by Phones for You on day one at page 46. I won't linger on the first, a negative response or red card, because that didn't happen. Turning to the thought experiment in paragraph 38 of Phones for You's skeleton, a positive response, CMA's position is that a positive response to an invitation to collude of this kind would indeed give rise to consultation. But to be clear, I am not saying that those are the facts of this case. But we do respectfully disagree with the submission made by Telefonica that a positive response could not, as a matter of law, give rise to consultation if the original disclosure was not sufficiently precise.
Well, I recollect I asked that specific question.
You did, my lord.
In the context of what if Mr. Swanty, having understood what Mr. Dunn was telling him, Mr. Swanty had actually said something positive, and I think I'm right in recollecting Mr. Hoskins said that still wouldn't be enough because of the lack of specificity. I'm not even trying to say that word again.
Yes, my lord. And my response to that is that there is no rule of law that precludes a positive response, that if, hypothetically, Mr. Swanty had said, by Jove, let's play those big cards, that would itself communicate information about EE's contemplated conduct towards the indirect channel. Now, Telefonica cited the HSBC case, but in my submission, all the General Court was doing there was making findings based on the evidence as to what some of the traders said to one another. Turning to what the judge found actually happened, a passive response, I'd make 4 points, if I may. First, as my Lady Justice Falk observed on Monday, day 1, page 57, passivity may give rise to consultation, but that, of course, that depends on the context. Second, where the context is that the communication in question does not remove or reduce uncertainty, perhaps because it's wholly vague or woolly, then my submission, silence in that context, does not give rise to consultation. Third, where the context is one competitor meets with another in private and talks about its future conduct, the other competitor does nothing to distance itself from the matters discussed, then it will in those circumstances be taken to have tacitly accepted the information. And in my submission, the Advocate General considers that point in the Aturus case, and it is indeed helpful to see, as a matter of the legal principles, what he had to say. That's in Authorities at tab 51, at page 2990.
51.
Yes, my lord. And it starts at paragraph 44, and you can see here the Advocate General says the court hasn't yet clarified the circumstances in which unilateral communication may result in a concerted practice. In paragraph 45, you see the reference to the familiar quote from the cement case. Paragraph 46, we see here that the Advocate General does say that concerted action has to be the result of a consensus, but goes on to emphasise the level of formalisation of that consensus shouldn't be subject to overly rigid requirements, a point that echoes what this court said in the Argos case at paragraph 22. And then what the Advocate General goes on to say in 47 and 48 is that, yes, reciprocity can encompass tacit approval, but of course it depends on the context of the communication. And then in 49, the Advocate General explains that where an undertaking receives information relating to an illicit initiative, but which we understand him to mean an anti-competitive disclosure, and doesn't oppose it, its acquiescence in that initiative may be inferred from the absence of a response, provided that the circumstances are propitious to the formation of a tacit consensus. And so...
Sorry, you're not suggesting, are you, that every bi-parte two-way meeting where there's silence must mean acquiescence? It's depending on the circumstances.
Yes, my lady.
Silence in some circumstances may mean various things.
Yes, my lady. It depends on the impression that is conveyed to the disclosure.
That's
Yes,
what he goes on to say, isn't it? The lack of opposition. Under certain circumstances, mere lack of reaction from the addressee will lead the other party or parties to believe that the addressee subscribes to the illicit initiative and will comply with it. And what's referred to there is the Portland cement again.
Yes, paragraph 82 of Owlborg Portland.
Yeah, and that picks up on the JGD sports point as
exactly
well.
Right, my lord, at paragraph 1043. And so, to be clear, it's not a matter for the CMA arguing for a particular outcome. We're just simply seeking to assist the court with what the legal principles ought to be. And if the judge were right to find in paragraph 217 that Mr Dunn's remarks were too vague to remove uncertainty in EE, then it follows that the circumstances, as the judge found, would have been such that Mr Dunn could not infer acquiescence from Mr Swanty's silence. Yep. In other words, if the court is content that the finding in 217 is correct, both in terms of the facts it found and the law that's been applied, then the CMA would agree that the circumstances would not give rise to acquiescence from Mr Swanty's silence. In light of the objection raised in terms of the CMA seeking to assist the court with what it thinks that the judgment says, I don't propose to comment further about Mr Swanty's silence.
No, I think that's what it is.
I then turn to ground 2, and if I may, I would make 5 points very briefly.
Yeah.
The first is, on a harmonious note, the CMA agrees with EE that there are 2 presumptions laid down in Anic, and that they are different from one another. And just to identify them, one is a presumption of participation in an anti-competitive meeting, and EE's leading counsel showed you that was established in paragraph 96 of the judgment in Anic, tab 36, page 2153. For my part, I'd call that the Owlborg presumption to distinguish it, and that's because the court explains the rationale for that presumption in its judgment in Owlborg. That's at core tab 18 at page 324. Now, in its supplemental skeleton, EE, this is at core 9.1, page 2236, seemed to portray this presumption as being only about anti-competitive agreements.
Sorry, whose supplemental?
EE supplemental skeleton, my lady.
No, do you mean EE?
I do, my lord. It's EE put in a supplemental skeleton for which it was granted permission, which is at core bundle, tab 9.1, at page 223.6.
Okay.
And the submission was made that this Owlborg presumption is limited to agreements. And whilst I would accept some of the cases refer to agreements being concluded at meetings, in my submission, the court has, in other cases, referred more broadly to participation in collusive meetings. And indeed, one can see that from the judgment that my learned friend took the court to in Total Marketing. There's no need to turn it up. It's paragraph 20, to be found in tab 50 at page 2969 of the authorities bundle. And to be fair, my learned friend for EE accepted that it applied to concerted practices on day 3 at page 98, lines 3 to 6. So that appears to be common ground. Of course, the other presumption, which is commonly referred to as the Anic presumption, is the one of a causal connection between consultation and conduct in the market. And that was rightly identified by the judge at paragraph 79 of the judgment, at page 282 of the core bundle.
Paragraph 79.
And it is the presumption laid down by the Court of Justice in paragraph 121 of the Anic judgment. Now, what I would like to add in relation to the Anic presumption of a causal connection is that the Specialist Competition Appeal Tribunal has explained both the rationale for the presumption and, moreover, how it might be rebutted in the Tesco case. A bold submission was made that this case is per incuriam for being overruled by the Aturas case, but in my respectful submission, EE correctly interprets Aturas as, in paragraph 49, dealing with the Anic presumption and therefore not closing the category of evidence that can be adduced to seek to rebut the Anic presumption. If I may, could I show the court 2 passages from the Tesco case?
Yeah.
The first is tab 12 at page 644.
Is a bottom line on this that you don't have to have public distancing to rebut the Anic?
Exactly right, my lord. And we can see that in the Anic case itself, and we can see that in the Tesco case, which I'm going to show you.
Speaking for myself, I need quite a lot of convincing that somehow there was a different test that was applied to meetings than to anything else. But anyway, let's show us what...
If I could just briefly show you, first of all, paragraph 51, and you can see here the tribunal...
Sorry, this is Tesco, is it?
This is Tesco, my lady, yes. And you can see here that the tribunal explains the presumption in Anic is justified by the commercial and economic reality that competing undertakings are likely to take into account how their competitors are planning to behave when determining their own strategy and conduct. And then turning to the rebuttal, that is to be found on page 690.
Yeah.
It's paragraph 277. And we can see here it's referring to T-Mobile, a later case that concerned the Anic presumption. And we can pick it up in the third sentence. We consider it's possible to rebut the Anic presumption by showing that an undertaking has repudiated the influence of the contact communication in question and can show that it closed its mind to the knowledge otherwise gained. And then the tribunal gives an example, which is somewhat reminiscent of the unfortunate example given on Wednesday of a recipient having a heart attack. Here we have the example of an undertaking immediately exiting the market, so it's no longer on the market and therefore can't use the information in any way. We can see that the tribunal says that it's in those rare circumstances the practice is not concerted. And so I take 2 points from this. First, the legal standard for rebutting the presumption.
And the point that's been, just looking at the actual facts there, it's making the point that the confidential information obtained, which had been obtained, actually went into the public domain before they could have used it.
Exactly
so
right,
that's
my lord.
another way of rebutting the presumption.
Exactly right, my lord. So one of the, so far as I'm aware, one of the only examples of where the Anic presumption has been rebutted, other than, of course, in this case, is in the Tesco case. Because what had happened, in that case, it was a hub and spoke conspiracy. So Sainsbury's were talking to a common supplier, passing their intentions on. And the point, as my lord has observed, is that by the time the Tesco buyer received the information actually information was in all the shops and was publicly known and couldn't be used, therefore, to reduce uncertainty. So the tribunal found that the presumption was rebutted in that case. My final point is that, again, on a harmonious note, the CMA agrees with EE that the categories of evidence for rebutting the Anic presumption are not closed. And that is the point that the CMA made in paragraph 56 of its written observations. And that's in the core bundle, tab 27, at page 998. Now, on Monday, my Lady Justice Falk queried the consistency of what is said in 56 with the point made in the first sentence of paragraph 63 on page 1000. And my answer is that they're dealing with different things. The point in paragraph 56 relates to the Anic presumption of a causal connection, whereas the point in the first sentence of 63 is that it relates to the Aalborg presumption, and of course only the latter can be rebutted by evidence of public distancing. My lords, my lady, those are the submissions that the CMA wished to make.
When you say in your meaning there, participation, and you're talking about participation in a meeting or in a broader...
So, my lady, right to clarify that, the Aalborg presumption of participation are in meetings at which anti-competitive agreements and or concerted practices have been reached. And I think that the court clarified that with counsel for the main parties earlier in the week, that presumption bites where you already have an anti-competitive
collusive... an anti-competitive agreement or whatever.
Or a concerted practice, yes, my lord. So it already exists. And therefore, if you want to avoid liability in relation to that, then the law requires public distancing.
Thank you.
So if they all meet and agree, and you sit there and do nothing, you're going to be caught unless you stand up and say, well, I'm having nothing more to do with this. I want to see the CMA putting it in.
That's exactly what the tribunal says in JJB Sports.
Yeah, the reason I wanted to clarify, I'm not sure it's limited to meetings, because look at the facts of Ituris itself. Those who knew about the discount limitation were taken to participation. It doesn't need a meeting, but it needs knowledge.
I'm very grateful, my lady. I would agree with that. It's about participation in an anti-competitive collusive behaviour. Whether you're doing that on WhatsApp or any other platform or a meeting or Teams.
Or a Teams call or whatever.
Exactly. The form by which you reach that collusive behaviour does not matter. Competition law focuses on substance.
Yeah.
And the CMA doesn't propose to comment on the judge's findings in relation to the rebuttal of the Anic presumption. In conclusion, I would wish to make clear that under the practice direction, the CMA was granted permission by the Chancellor to make written and oral observations on issues relating to the application of competition law. And it was in light of the way in which Phones for You opened submissions on Monday, but more importantly, how the court was concerned or troubled by a potential inconsistency in the findings made in the judgment, that all the CMA was seeking to do was to assist how it sees the import of the findings in 197. It wasn't seeking to re-argue the case. I made very clear that we weren't at the trial. I made very clear that we're not seeking to second-guess the trial judge. And I obviously apologise to the court if it feels that the CMA overstepped. It was just seeking to assist with setting out its understanding of how the law applies to the facts found by the trial judge. And unless I can be of any further assistance,
thank you very much.
Those are the CMA's submissions.
Well, sorry, I know there's only a couple of minutes before we rise for lunch. Can I make two comments about what's happened this morning? One is of a general nature and one is of a specific nature.
Yes.
The general comment is this. The CMA has a power to intervene. It should obviously be able to do so. It should be welcomed when it does. However, what has happened today is that the CMA has overstepped what it should have done. It's not for the CMA, just because it's a competition case, to come to a court, especially to an appeal, and construe the factual findings of the judgment.
Well, I see the absolute force in that, and that in any event is for the court, not for the CMA.
And I make the point of the matter for you whether the court would find it appropriate to give some guidance as to what would be what the appropriate scope of intervention would be, because obviously We don't want this happening in another court, in another time, and some big
We'll
place
have to
in
think
the
about that, Mr. Hoskins. We've got quite a lot to
You have
contend with anyway.
But this is important because we see this happening in competition cases. We see the CMA come in. If they're for you, it's great. If they're against you, you sit there. Now, if they're doing their job and coming in and talking on the law, obviously that's how the legal system is supposed to work. But if they'd overstep the market, it is really unfair, and this court may want to say something about that. The second point is specific to this case. Is for obvious reasons, I've got a right of response to the CMA, and I'm not going to respond to the points they've made about construction of the judgment,
No.
because that just compounds what's happened. Right. But Mr McLean is a wily old fox. And I mean that as a compliment.
I'll take the word old out of that.
He's absolutely right about that.
We know each other well enough, I think that got to be an insult. I can guess his reply is going to be now, and I don't have a right to reply to that. All I can do is say I am absolute faith that the Court of Appeal is more than robust enough to put.
Well, let us put it this way: we've got limited time anyway. If Mr. McLean, as it were, adopts what's been said in some way, and you feel in the circumstances you should be entitled to say something in rebuttal, as it were, we will permit you to do that. It will have to be done in writing, but let's see how we go.
I think we'll see what happens.
Does that deal with the point?
The writing option may be more appropriate because we have.
I think we can't limit what Mr. McLean says in reply if he's permitted, if it falls within what he'd be entitled to think up for himself, as it were. I follow the point that I'm sorry if I wasn't thinking actually when I said they could have spoken to each other. I was just opening my big mouth without thinking about the implications, because obviously the position of the CMA is meant to be an entirely neutral one as the regulator. Does anybody else want to say anything?
Well, one final one. We understand on this side of the court that there was in fact a complaint by Phones for You to the CMA's predecessor, which was rejected. Now, if that is true, these submissions are doubly.
Well, I'm not sure we've ever heard that before.
Ironically, I am somewhat ambushed by being referred to a complaint that I haven't had detailed instructions from the CMA about the nature of that complaint, when it was made, what it related to. If the court would find it of assistance, I can of course take instructions over the lunch time adjournment.
If you manage to get instructions, then do. But in the general scheme of things, it may not matter.
I'm grateful.
Right. Okay. Well, where are we in terms of?
So where we are with timing is we're actually 15 minutes ahead.
Oh, there we are. Let's break now then.
And there's our replies, and then the CMA, and then finally there's.
So how long do you think you need?
So we were scheduled to have 15 minutes. We could actually have more than that and still finish by 4 o'clock, but hopefully we won't need. First thing I need to do is discuss.
Well, we've had quite a long morning anyway. Yes. I think it would be sensible to.
Oh, we can. Yes, we're not suggesting.
Let's break for lunch now and say 2 o'clock.